Good evening, and thank you very much for that introduction, which piles a lot of pressure on me to deliver a lecture which is both interesting and informative. I have prepared a written paper which I will submit for publication and throw myself at the mercy of the high standards of the review. Hopefully they'll select it. But a lot of the references that I make are to cases and other materials which are very extensively footnoted in the paper. So if you want to follow up some of the matters that I raise, then you'll have the opportunity when you see the paper. So it's a great pleasure for me to visit the law school again after many years to deliver tonight's lecture. The Law Review has come a long way since I was assistant editor in 1981, but I'm pleased to see that the core aim of excellence in legal scholarship remains the same. My topic of independence of Australian tribunals is very dear to me. As President of the Administrative Review Tribunal, I and my colleagues on the tribunal take our independence very seriously. A useful place to start for tonight's presentation is our Constitution. Under Australia's separation of powers doctrine, administrative tribunals are part of the executive branch in Chapter 2 of the Constitution. They are not courts exercising judicial power under Chapter 3. As such, independence is not one of their defining characteristics within the meaning of the Cable principle. Rather, they are statutory bodies whose independence can vary according to the Act which establishes them. Today, the importance of independence for administrative tribunals is generally accepted by Australian legislatures. However, that was not always the case. When colonial governments and legislatures began to establish administrative tribunals in Australia, the tribunals were generally considered to be part of the machinery of government rather than independent bodies tasked with conducting robust, arm's-length reviews of government decisions. Since those early beginnings, there's been a gradual attitudinal change regarding the need for administrative tribunals to be, and to be seen to be, independent. I will consider key developments in the establishment of administrative tribunals and the extent of their independence in 4 historical periods. They are pre-Federation, 1901 to 1950, 1951 to 1970, and 1971 to 2024. Before discussing the first of those periods, it is necessary to clarify the types of tribunals that fall within the scope of my paper and the meaning of independence for present purposes. My paper deals with tribunals established by government not to make primary governmental decisions, but to perform an appeal or review function in relation to such decisions. In the present context, such tribunals are independent if their members are free of any loyalties, duties, or interests that might inappropriately influence or interfere with the performance of their functions. Tribunal members must be able to make decisions in accordance with the law, irrespective of their personal preferences and without having regard to whether a decision will be unpopular with the government of the day or generate adverse publicity. They must not be subject to direction from any minister or other public official. There must be no capacity for any form of adverse consequences for the tribunals if they make decisions which are unfavourable to the government of the day. Independence requires that all decision-making processes by an administrative tribunal are themselves transparent and in accordance with the rule of law. If a party is unhappy with the tribunal's decision, the avenue available to them to overturn the decision should be an appeal to a court or a judicial review proceeding. A tribunal is not independent if appeals against its decisions may be made to a minister. Independence is essential to an administrative tribunal's capacity to properly perform the critical role of ensuring that decisions it reviews are lawful, transparent, and appropriate in the circumstances of a particular case. So with that scene setting, I now turn to the pre-Federation period. In this period, the predominant conception of administrative tribunals was as bodies that performed public functions and made decisions as part of the delivery of government services. However, there were early examples of executive bodies performing an appeal or review function in respect of governmental decisions. Oddly enough, the colonial governor or executive council performed a review function in some circumstances. For example, in New South Wales, under Section 9 of the Police Regulation Act of 1852, a police officer dismissed for, quote, neglect or violation of duty in his office, end quote, could appeal to the governor. The governor could affirm the decision in order to, or order a further inquiry and rely on the report of the inquiry to decide whether the police officer, quote, shall be dismissed or restored to his office, end quote. You'll notice the his because they were all men at that time. A Victorian example in Section 41 of the Customs Act of 1883. It provided that a person, quote, aggrieved by the determination of the Commissioner, end quote, may have their grievance considered by way of an inquiry by a panel deputised by the Governor in Council. Interestingly, that section provided that the conduct of the panel inquiry, quote, shall be in as close conformity as the nature of such inquiry will admit with the practice adopted before justices on inquiries had before them, end quote. The panel which conducted the inquiry was required to produce a report for the Governor in Council. It then fell to the Governor in Council to, quote, decide the case upon such evidence and make an order upon consideration of the facts, circumstances and evidence so reported, end quote. It is significant that this early iteration of a hearing of an appeal from a determination of an executive officer should draw upon the example set by the courts, albeit that the findings of the panel were then reduced to a report and the case ultimately determined by the Governor in Council rather than the panel itself. This suggests that even in the pre-Federation era, some consideration had been given to how accountability and transparency of decisions of colonial executive officers could be improved. Outside the appellate function performed by governors and executive councils, there were few pre-Federation bodies that performed an appeal or review function in relation to government decisions. One example is the New South Wales Minister for Lands, who had power under the Crown Lands Act of 1884 to hear appeals from decisions of local land boards relating to compensation and other matters pertaining to the Crown lands for which they were responsible. It is notable that the 1884 Act required both the boards at first instance and the Minister on Appeal to sit, quote, as in open court, end quote. It is also notable that the Minister had power under Section 19 to remit a case to a board for the purpose of the board taking further evidence, in which event the board could, quote, after hearing such evidence, reverse, alter or amend its previous decision in any way it may consider necessary, end quote. So this is an early example of the power to remit, which is a common feature of modern review bodies. The next period is from 1901 until 1950. Because of the large number of appeal and review avenues that existed during this period, I will focus on two administrative review mechanisms, both of which were the subject of judicial scrutiny. They are first the Repatriation Commission and its associated bodies, the War Pensions Entitlement Appeal Tribunal and the Assessment Appeal Tribunal, and secondly, the ill-fated Taxation Board of Appeal and its more durable successor, the Taxation Board of Review. The functions that the above bodies performed continue to this day, with reviews concerning veterans' entitlements and taxation now being undertaken by the Administrative Review Tribunal. Turning first to the Repatriation Commission and the War Pensions Appeals Tribunals. Merits review of administrative decision-making to protect the rights of ex-service men, and that's the terminology that was used because they were ex-service men. So their entitlements to war pensions and associated benefits dates back to the War Pensions Act of 1914. The Australian Soldiers Repatriation Act of 1920 established a repatriation board for each state to assess pensions for returned soldiers and their dependents. The 1920 Act also established the Repatriation Commission as a statutory corporation that was akin to a government department. The 1920 Act conferred a right of appeal from decisions of a state board to the Repatriation Commission. The 1920 Act was amended by the Australian Soldiers Repatriation Act of 1929 to confer a right of appeal from the Repatriation Commission. First, to the newly established War Pensions Entitlement Appeal Tribunal for decisions concerning eligibility for a war pension. Secondly, to the newly established Assessment Appeal Tribunal for decisions concerning a returned soldier's incapacity and therefore the amount of pension payable. The 1929 Act inserted Section 45(w) into the 1920 Act. Section 45(w) subsection 2 provided that each of the two tribunals was not bound by the rules of evidence, quote, but shall act according to substantial justice and the merits of the case, end quote. This formulation finds its way to the legislation of many modern tribunals. The 1933 case of the Queen against War Pensions Entitlement Appeal Tribunal, ex parte Bott, concerned whether the War Pensions Entitlement Appeal Tribunal had complied with the rules of natural justice. Interestingly, the plurality in that case stated that the tribunal was not bound to consider only the evidence that was before the Commission, but could, quote, take into consideration whatever evidentiary matters it thought proper, end quote. So this is also a feature of many modern tribunals, that they are not bound by the materials that were before the original decision maker. In that Bott case, Justice Evatt, in dissent, stated that the general design of the 1929 Act was to give returned soldiers, quote, the right to secure a review of any adverse departmental decision by entirely independent appeals tribunals, end quote. As will be seen, Justice Evatt's focus on the independence of the appeal tribunals was unusual for this period. His observation represents one of the earliest judicial acknowledgements of the importance of independence for administrative tribunals. I now turn to the taxation boards. The Taxation Board of Appeal was established by the Income Tax Assessment Act of 1922. It represents one of the most important early examples of Parliament recognising that a review tribunal consisting of members with specialist expertise is capable of providing a simpler, cheaper and more efficient remedy than a court. The board consisted of a chairman and 2 other members, all of whom were appointed for a term of 7 years. The chairman was usually a senior executive ranking official from the taxation department. In other words, the chairman was an insider, a departmental officer. One of the 2 other members was usually a lawyer and the other member was usually an accountant. The board was empowered by sections 44 and 51 of the 1922 Act to hear cases that were referred to it at the request of a taxpayer who was dissatisfied by a decision of the Commonwealth Commissioner of Taxation, and to make such orders as it thought fit. A review of the board was an alternative to a challenge to a decision in a court. Under the 1922 Act, the Taxation Board of Appeal could decide both questions of law and fact, and its decisions on questions of fact were stated in Section 52, Section 51, subsection 2, to be final and conclusive on all the parties. So this feature, that its decisions are final and conclusive on all parties, including the fact that the tenure of the members of the board were limited to 7 years, rather than was the case then for judicial officers for life. So these are some of the features of the board that led the High Court to find in the 1925 case of British Imperial Oil Company Limited against the Federal Commission of Taxation that the board was unconstitutional. That was held to be so because it was an executive body rather than a court, and the legislation purported to confer upon it part of the judicial power of the Commonwealth. As a result of the British Imperial case, Parliament enacted the Income Tax Assessment Act of 1925. The 1925 Act replaced the Taxation Board of Appeal with the Taxation Board of Review. And this new body was intended to be an administrative body exercising the same powers and functions as the Commissioner, rather than a body exercising judicial power. The 1925 Act was set to assimilate the board to the Commissioner. It replaced Section 44 and Section 51 of the 1922 Act with new provisions. The new Section 44 provided that the board's decisions were deemed to be those of the Commissioner, and the new Section 51 no longer stated that the board's decisions on questions of fact were final and conclusive. The Taxation Board of Review consisted of a chairman, usually an executive from the Taxation Department, and 2 additional members, one drawn from the legal profession and the other from the accounting profession, as was the case with the earlier Appeal Board. Each term of office was limited to 7 years, but members were eligible for reappointment. In the 1926 case of Federal Commissioner of Taxation against Munro, the High Court by majority held that the powers conferred on the Taxation Board of Review were not part of the judicial power of the Commonwealth, and therefore the board was not unconstitutional. Justice Isaacs described the board as, quote, having a true administrative character and affording a practical means of reconsidering business matters without the intricacies, delay and expense of legal proceedings, end quote. Justice Higgins described the board as, quote, auxiliary to the Commissioner in the administrative functions, end quote, and concluded that the board, quote, ought to be treated as a mere piece of administrative machinery, end quote. So I want to highlight those words, a mere piece of administrative machinery, because they're relevant to some of the analysis that I'll speak to shortly. In the Munro case, Justice Stark stated that the board's functions, quote, are in aid of the administrative functions of the government, end quote. In Munro, the High Court also dealt with a separate proceeding by British Imperial Oil Company Limited. That company changed its name to Shell Company of Australia Limited, and under that name, it appealed against the High Court's decision in Munro to the Privy Council. In 1930, in Shell Company of Australia Limited against Federal Commission of Taxation, the Privy Council affirmed the decision of the High Court that the Taxation Board of Review was not unconstitutional. The Privy Council stated that the board, quote, appears to be in the nature of administrative machinery, so you have this terminology of machinery again, to which the taxpayer can resort at his option in order to have his contentions reconsidered. And again, you see the male gender throughout all this period. The Privy Council added that the board, quote, is merely in the same position as the Commissioner himself, namely, it is another administrative tribunal which is reviewing the determination of the Commissioner, who admittedly is not judicial but executive. 5 years later, in the 1935 case of Jolly against the Commissioner of Taxation, Justices Rich and Dixon referred to the Privy Council statement in shell and then said that the board, quote, is only another executive body in the administrative hierarchy, end quote. Interestingly, a few paragraphs earlier, they stated that, quote, one of the purposes of the board was intended to serve was the independent review of cases falling within the Commissioner's discretionary power, end quote. So the phrases, quote, another executive body in the administrative hierarchy, end quote, that Justices Rich and Dixon used in Jolly is similar to the phrase administrative machinery that Justice Higgins used in Munro and the Privy Council used in Shell. These descriptions of the Taxation Board of Review indicate that in the 1920s and 1930s, the High Court and the Privy Council considered that an Administrative Review Tribunal need not be independent of the administrative body whose decisions it reviews. Rather, the tribunals could be, quote, assimilated, end quote, with that body, or be, quote, auxiliary, end quote, or in aid of that body. In other words, the tribunal and the decision maker whose decisions the tribunal was empowered to review were part of the same administrative apparatus. The reference by Justices Rich and Dixon to independent review in Jolly is not inconsistent with the then prevailing view about the independence of administrative tribunals. That is because the reference is to the nature of the review being conducted by the Taxation Board of Review rather than the nature of the board itself as an institutionally independent body. In other words, the board was seen by Justice Rich and Dixon as being part of the same administrative machinery or hierarchy as the Commissioner of Taxation, and that it was tasked with conducting an independent review of the Commissioner's decisions. By contrast, as I indicated earlier, in Bott, Justice Evatt in dissent focused on the independence of the War Pensions Appeals Tribunals themselves rather than the independence of their review functions. I pause here to observe that, in my opinion, the modern notion of a merits review body has its origins in the Taxation Board of Review. Although the board was not independent by today's standards, the rationale for its establishment as an informal and accessible review mechanism that focused on the substance of an applicant's grievance rather than legal form and technicality continues to be relevant to administrative tribunals today. I now turn to the period between 1951 and 1970. During this period, a large number of administrative review tribunals were established at the federal level to deal with matters such as the regulation of the arts, the provision of medical services, copyright and trade practices. The Taxation Board of Review was a subject of further consideration by the High Court during this period. In 1963, in Mobile Oil Australia Proprietary Limited and Federal Commissioner of Taxation, Chief Justice Dixon described the Taxation Board of Review as, quote, another administrative authority. He stated that its purpose of enabling a taxpayer to refer a matter to the board, quote, seems to have been to provide a less formal method of investigating facts and a hearing, an opportunity of exercising discretion and the like by a more detached administrative process. The ad hoc and uncoordinated manner in which a plethora of different review tribunals and boards were established after the Second World War made it difficult to assess their efficiency and efficacy in securing public confidence in executive decision-making. The next period is 1971 to 2024. It was against the backdrop of a multiplicity of ad hoc tribunals and the absence of a generalist federal court that the Commonwealth Government established the Administrative Review Committee on 29 October 1968, chaired by Justice John Kerr. The Kerr Committee published its report on 14 October 1971. Coincidentally, the Administrative Review Tribunal commenced operation on 14 October 2024. The key recommendation of the Kerr Committee was the establishment of a generalist tribunal, which it described as the Administrative Review Tribunal, to review decisions on the merits. So again, coincidentally, the original name that was envisaged for what became the Administrative Appeals Tribunal was actually the Administrative Review Tribunal. So in one sense, we've gone around full circle. So the Kerr Committee advocated the establishment of a generalist review tribunal. This was seen as preferable to the proliferation of specialist tribunals. Underpinning the Kerr Committee's recommendation was its analysis of the limitations and problems associated with judicial review of government decisions by courts. One of the striking features of the Kerr report, which everyone cites as a seminal report for the establishment of merits review in Australia. One of the striking features of that report by today's standards is that the Kerr Committee did not appear to be very concerned with the institutional independence of the proposed tribunal. In the entire report, the Kerr report, there is only one reference to independence. And ironically, it was the advocation of something which was not conducive to independence. This is a quote from the report. We see no objection to departmental officers being appointed to membership of tribunals when the process of adjudication is seen as arising naturally out of the course of administration. We do not think that complete independence is necessary. Because private rights are affected, we are of the opinion that, where possible, part of the membership of the tribunal should be drawn from outside the public service, end quote. So what the Kerr Committee said was it was perfectly natural for a departmental officer from the department whose decision is under review to sit on the tribunal. But it would also be good to draw upon non-public service individuals to sit on the tribunal from time to time. The Kerr report also concluded that there was no need for the proposed tribunal to operate from premises that were physically separate from the premises of ministers, departments and agencies whose decisions were being reviewed. Further, the Kerr report responded to concerns that a generalist tribunal would not have the necessary experience or expertise by stating that, quote, an officer of the Commonwealth Department or authority responsible for administering the decision under review could sit on the tribunal. Following the publication of the Kerr report, the government established the Committee on Administrative Discretions, chaired by Sir Henry Bland. Its role was to examine administrative discretions under Commonwealth statutes and regulations and to advise as to the appropriateness of providing merits review or alternative external review of those decisions. The Bland Committee described review tribunals as, quote, an extension of administration and, quote, an extension of the administrative decision-making process. However, the Bland Committee explicitly rejected the Kerr Committee's view about Commonwealth officers from the department or authority responsible for the decision under review hearing those proceedings in the tribunal. The Bland Committee stated, and I quote, we would be concerned about the public reaction to a member of the tribunal adjudicating a decision of his own department. In some cases, departments might be the only suitable sources of one member of the tribunal. There might be less offence in principle if a departmental officer from a department other than that involved were a member on an ad hoc basis, end quote. So the difference between the Kerr Committee and the Bland Committee is that the Kerr Committee said an officer of the department which made the decision under review could sit on the tribunal. The Bland Committee said that they'd be concerned about that, but it was all right by them if an officer from another department, still employed by that department, could come sit on the tribunal, make the decision and go back to their normal public service job. They're considered by reference to basic principles of modern merits review that a review body must not only be independent but also be seen to be independent. The attitude of both the Kerr Committee and the Bland Committee to departmental officers participating in reviews by the tribunal would appear to us to be quite extraordinary. The Bland Committee recommended the establishment of a general administrative tribunal. The generalist body that the Kerr and Bland Committees recommended became the Administrative Appeals Tribunal, or AAT, which was established by the Administrative Appeals Tribunal Act of 1975 and which commenced operation on 1 July 1976. Given that the Kerr report stated that there was no need for the proposed tribunal to enjoy, quote, complete independence, end quote, and the Bland Committee considered the tribunal, quote, as an extension of government, it is not surprising that the independence of the AAT was not legislatively enshrined in the AAT Act. As enacted, the AAT Act did not refer to independence or provide that the members of the AAT must take an oath of office. An oath of office was first mandated in 1982. That oath focused on allegiance to the monarch and required members to, quote, faithfully and impartially perform the duties of their office, end quote. I hasten to add that the absence of any statements in the AAT Act regarding the independence of the AAT does not mean that it was not intended, sorry, does not mean that it was intended that the AAT would lack independence. Nor does it mean that the case law supported any proposition that the AAT did not operate independently of the bodies whose decisions it reviewed. The AAT's independence was emphasised by the then Attorney General in his second reading speech on the Administrative Appeals Tribunal Bill of 1975. The AAT's independence was also emphasised by the inaugural president of the AAT, Justice Brennan, in many cases including in Re Becker, a Minister for Immigration and Ethnic Affairs in 1979, and by the full court of the Federal Court in a number of cases, including Drake, a Minister for Immigration and Ethnic Affairs. Many other cases also referred to the AAT as operating independently and its processes being more akin to those of a court. On 1 July 2015, the then separate Social Security Appeals Tribunal, or SSAT, the Migration Review Tribunal and the Refugee Review Tribunal, RRT, were amalgamated with the AAT. The SSAT has an interesting history. It originated not in legislation, but in a ministerial instruction dated December 1974. It was tasked with merits review of pensions and allowances decisions by the Department of Social Security. However, it could not change the decisions that it reviewed. It was limited to making a recommendation to the Director General of Social Security about how the matter should be resolved. In its original form, that tribunal comprised a full-time officer seconded from the department and 2 part-time members, one of whom was a lawyer and the other of whom had qualifications or experience in welfare. Although most of the recommendations of the tribunal were accepted by the department, one could not describe this initial emanation of the SSAT as truly independent because it was chaired by a serving departmental officer. Really, it could be described as an internal review body. The Social Security Review of Decisions Act of 1988, or the SSRD Act, established a statutory SSAT with power to make binding decisions. So it was not until 1988 that the Social Security Appeals Tribunal had legislative backing and it could alter the decisions it reviewed. The Immigration Review Tribunal was established in 1989 and became the Migration Review Tribunal, or MRT, in 1998. The RRT was established in 1992. In broad terms, the RRT reviewed decisions by the Minister for Immigration in relation to protection visas or refugee visas, and the MRT reviewed decisions concerning a range of other visas such as student visas. As was the case with the AAT Act, the word independent was not used in the legislation establishing these migration review tribunals. However, under their legislation, those tribunals had many of the independence features of the AAT. In particular, they could control their own procedures and had power to set aside the original decision and substitute their own decisions. Section 6 of the SSRD Act inserted Section 176 into the Social Security Act of 1947 and provided that the SSAT, quote, shall in carrying out its functions under this Act pursue the objective of providing a mechanism of review that is fair, just, economical, informal and quick. So this language, which was originally used at that time, has found its way into many other modern review tribunals legislation, including ultimately in the AAT Act when that was amended in 2005. But it's to be noted that the reference is to a mechanism of review without any reference to that mechanism being independent. I'll now turn to two concepts that were associated with the AAT, which I think followed from the original conception of the AAT as being part of the administrative machinery, following from the Taxation Board of Review. And they are the concepts of the administrative continuum of government decision-making and the concept of the AAT stepping into the shoes of the decision maker. The concept of the administrative continuum was probably inspired by the High Court's decisions in Munro and Jolly and the decision of the Privy Council in Shell in the 1920s and 1930s, and the High Court's decision in Mobile Oil in 1963 regarding the Taxation Board of Review. A variant of the expression administrative continuum was used by Justice Davies in 1988 in the case of Jebb and the Repatriation Commission. Justice Davies said, quote, "The general approach of the tribunal has been to regard the administrative decision-making process as a continuum and to look upon the tribunal's function as part of that continuum so that within the limits of a reconsideration of the decision under review, the tribunal considers the applicant's entitlements from the date of application or other proper commencement date to the date of the tribunal's decision," end quote. Justice Davies made the above observation in rejecting the proposition that the AAT was required to consider an applicant's claim on the basis of the circumstances existing at the time the claim was lodged with a department or agency rather than at the time that the AAT considered the matter. The expression administrative continuum has been repeated in several Federal Court and High Court cases since Jebb. The expression being in the shoes of the original decision maker was used by Justice Smithers in 1980 in dissent in Minister for Immigration and Ethnic Affairs in Pochie. He said that, quote, "In reviewing a decision, the tribunal is to be considered as being in the shoes of the person whose decision is in question," end quote. Justice Smithers made this observation in support of the proposition that in reaching a decision on review of a decision of the original decision maker, the AAT should consider itself as though it was performing the relevant function of that decision maker in accordance with the law as it applied to that person. Variants of the expression being in the shoes, including stands in the shoes and steps into the shoes, have been used in numerous cases since Pochie. The metaphor steps into the shoes sought to convey that in reviewing a decision, the AAT will have the same powers and discretions as the department or agency which made the decision and will be subject to the same legislative constraints. In my view, the concepts of the administrative continuum and steps into the shoes detracted from the appearance of the AAT's independence because they conveyed that the AAT was part of the process of departmental decision-making. The fact that those concepts gained currency is not surprising when one has regard to the fact that at the time the AAT was established, there was less concern about the need for it to be seen as independent from the rest of the executive branch than there is today. You'll be pleased to know that I'm now at the final part of the presentation, and that is about the ART. Independence is a core institutional feature of the ART, which is entrenched in the Administrative Review Tribunal Act of 2024. Independence from administrative decision makers was a primary consideration in the government's policy to establish the ART. In the second reading speech on the Administrative Review Tribunal Bill, the Attorney-General said the following: "A strong, user-focused administrative review body provides an avenue for community members to seek independent review of government decisions that have major and sometimes life-altering impacts on their lives," end quote. The revised explanatory memorandum to the ART Act included the word independent more than 40 times. The independence of the ART is also reflected in its statutory objective in Section 9 of the ART Act, which requires the ART to pursue the objective of providing an independent mechanism of review. Now, it would be recalled that in relation to the AAT and the migration review bodies that amalgamated with it, there was reference to a mechanism of review without the word independent featuring as part of that description of that mechanism. Section 213 of the ART Act provides that members must take an oath of office to, quote, "well and truly serve the office of member and do right to all manner of people according to law without fear or favour, affection or ill will." So this word is quite different from the oath that AAT members took, which focused on allegiance to the monarch and impartiality. The wording of the oath that ART members take is identical to the oath that federal court judges take, and that oath is universally associated with judicial independence. The independence of members of the ART is fortified by the requirement in the ART Act that members can only be appointed if they have been assessed as suitable through a publicly advertised merit-based appointment process. There was never an equivalent requirement in the AAT Act. This requirement assists in fostering public confidence in the ability of ART members to exercise their significant powers to alter government decisions competently, responsibly and independently of government. I think there is now symmetry between merit-based appointees to the ART making merit-based administrative review decisions. And as a matter of interest, I was also appointed following a merit-based selection process. So I wasn't tapped on the shoulder. I applied, I was interviewed, I was shortlisted, and then I was appointed. So when the Attorney-General called me and said, "You're my first choice," I could never be sure that that was the case. He could have called somebody else and they knocked him back before I was reached down the list, but I took him at his word. In my opinion, the above unique statutory features of the ART's independence warrant consideration by the courts of whether the concept that the AAT is part of the administrative continuum and the concept that the AAT steps into the shoes of the original decision maker should apply to the ART. There are other important factors which warrant consideration by the courts of whether the administrative continuum and steps into the shoes of concepts should be associated with the ART. Unlike ART members, the majority of federal administrative decision makers are not statutory office holders and they do not take any form of oath. Most of them do not make decisions as part of an independent statutory mechanism, but as part of the ordinary business of government, and they are subject to government policies and public service rules. An ART member has the same powers and discretions as the original decision maker, but must exercise them as an independent adjudicator. The procedures that are utilised by the ART in its decision making are more closely aligned to those of the courts rather than those of departments or agencies. The statutory objective provides that one of the elements of the independent mechanism of review is the promotion of public trust and confidence in the tribunal. By definition, people who invoke that mechanism feel aggrieved by the decision made by the relevant department or agency. Many of them are vulnerable individuals without legal representation. From their perspective, any notion that the ART is part of a continuum of decision-making by the relevant department or agency might exacerbate their sense of grievance and thus not promote public trust and confidence in the tribunal. Also, any notion that by stepping into the shoes of the original decision maker, the ART will be no different from the decision maker has the potential to cause confusion and apprehension and to obscure the fact that the ART is independent of and vastly different from the decision maker. The phrases being part of the administrative continuum and steps into the shoes of might appear at first blush to be a shorthand, convenient way of reflecting that administrative tribunals sit in Chapter 2 of the Constitution and that members of the tribunals have the same powers and discretions as the original decision maker. However, applicants to the ART are not concerned with issues such as in which chapter of the Constitution matters are heard. Instead, they want to access a mechanism of review which will hear and determine their claims on their merits fairly and justly, and importantly, independent of the agency or department from where the decision originated. There is a risk that the two phrases of administrative continuum and steps into the shoes of might obscure the fact that the tribunal is independent and incorrectly give the impression that the ART is part of the bureaucracy and conducts internal review. The ART takes its independence very seriously. A tangible indication of our commitment to independence is our adoption of a new logo. Unlike the ART's logo, the ART logo does not include the Commonwealth coat of arms. This should not be seen as merely tokenistic. Rather, it embodies our desire to convey to applicants who seek a review of a government decision that the review will not be conducted by another part of government by way of internal review, but by an independent statutory body that is robust and at arm's length from the original decision maker. I've taken up nearly all of the time. I think there is time for questions. Thank you very much for your attention.
Fantastic. Take a seat. That's fantastic. Okay.
Before we end, I just want to extend my thanks to a number of people. First, I want to thank all of you for being here today. It is really gratifying. Thank you for taking the time out of your busy schedules to spend this time with us. I also want to thank the team at MLS Events, in particular, Karina. Thank you so much for dealing with all of my emails and making this event so seamless. I want to thank also the review secretaries, Nikki, Jeremy, and Eleanor, and His Honour's Senior Associate, Emma, without whom today would not have been possible. Also, of course, my co-editors, Angela and Selena. I thank God every day that you are much smarter and much better at this job than I. And I want to thank, finally, Professor Rundle for her excellent introduction and her adept moderation. And actually, of course, most of all, I want to extend my thanks on behalf of the review to His Honour. Thank you so much for a stimulating and timely discussion as we head into a new age of merits review at the Commonwealth level. We are most grateful. Good night, everyone, and I hope you enjoy the rest of your evening.
Thank you.